Hello, I'm Bruce Margolin, and it's a pleasure to introduce you to Stuart Richland and Mr. Berry, who have put together a nice plan to get the city back on order to protect our citizens and our patients and the collectives in this new attempt to try to close them down. I'm confident these people's ability to do what has to be done. You know, they've been successful before in the last attempt by the city to bring this new statutes, and they got them enjoined, showing it was unconstitutional. And again, I think they've got some plans here that could be effective in ending the problem of the latest attempt in this lottery idea that the city has come up with. And I wish you guys luck, Mr. Berry and Mr. Richland. I know if anybody can do it, you can.
Our beautiful city of Los Angeles, home to a tremendous revolution, a social experiment in medical marijuana. And you, dear collectives, have established a fantastic business, and your patients rely upon you, and you have a really neat place. And yet, the city continues to put us on this insane roller coaster. The rules keep changing, and you're stuck in the middle, and we've got to stop the roller coaster. That's what this video is about. My name is Stuart Richland. I've been a lawyer for 25 years. My associate has also been a lawyer for 25 years in these matters. We want to kick some ass. We want to secure the rights of medical marijuana patients. We want to secure your rights as a collective. We want to confront it in the city of Los Angeles as we've done before. And those of you that have been following this topic know that we did it in December. We got the judge in the combined complex litigation to rule in favor of the collectives, and our collectives were part of the victorious plaintiffs that were listed on the injunction against the city of LA, and we want to do that for you and your collective. So let's get into it, and welcome to our little program. Well, we did it before, and we can do it again. You know, the last time we had to go on a tremendous uphill battle in order to get our injunction. The city attorney came up with all kinds of crazy arguments, really disingenuous arguments, unfair and really not logical arguments. But this judge threw them away, and now we're going to be in front of Judge Moore for a while. As far as we know, he'll be handling our supplemental complaint, and that means that we're going to be with the judge that we've sort of already informed about the issues of safe access and medical marijuana, and he's already done the brave thing of coming down on the side of medical marijuana patients and their collectives already. So we believe we have a darn good chance of being able to get another injunction. And before, when collectives hired us, there were just a few of them, and they had to pay quite a bit of money compared with what's going to be needed now. If we can get enough of you together to join in on the lawsuit, we're going to be able to scale the price way, way down, like ridiculously low. I don't even want to say the number, but it is entirely possible that we could do this for you for $1,000 retainer and $1,000 a month, as long as we get enough people. So it really comes down to the grassroots marketing and the grassroots interest among the collectives that are being told to shut down. If we can get them excited and interested in our legal theories and in our ideas for bringing another injunction and get enough of them on board, we can make it really reasonable for every collective to get great legal services. So for the next few moments, we're going to be discussing some of the legal theories, some of the problems with the collective ordinance that's been put forth, and why we think it should be taken away by an court, by an injunction. I'll introduce you to my buddy Graham Berry, who's also handling these cases with me, and the two of us together, I think, form a good balance of experience, and we both got over 25 years in the game, and we've been victorious together with this combination before. We know we can do it again, or we believe we can do it again, or we wouldn't waste your time. And, of course, we cannot make a guarantee. There are no guarantees in the area of law. But there are many arguments that are applicable to those of you that are being told to shut down, and we're going to give you a couple of those ideas as we roll forward in our little program. Thank you for hanging in with it. Thank you for joining me. Hey, Allison, thank you very much for touching base.
Hi, Stu. I just wanted to congratulate you on your last round of kicking ass against the city of Los Angeles. And I just wanted to really tell you, thumbs up to, I hope, your next conquest, which is, again, this unconstitutional regulation of dispensaries that's just not in the interest of patients and really isn't even constitutional. So good luck to you, and I hope that everyone out there who is fighting to stay open under state law. It goes to Stuart. We need people like you. Obviously, people need us at the unfortunate back end, we like to say, but if you can really help them so they can avoid us, that's really what it's all about. So,
True dat.
good luck.
Thank you. And of course, the way I feel is anytime anyone comes to me and they need criminal law assistance, it's about the Margolin firm. I think you guys kick ass as well, and thanks for lending a good word to what we're doing.
Thank you.
Peace.
Peace.
Hey, Graham, thanks for joining this little video talk. As you and I have discussed this new ordinance, I want to celebrate our prior victory together that we got an injunction along with the other fine attorneys that were working for plaintiffs against the City of LA's old ordinance. But it seems like this new ordinance, from what you and I have discussed, is just as bad or maybe even worse than the prior ordinance.
That's correct. It has many features which we believe are objectionable, which can be challenged on constitutional grounds, on equal protection grounds, on due process grounds. There are a number of features of it which ignore the ruling that the judge has already made in connection with his December 10 order, and we believe we can successfully obtain another preliminary injunction in connection with the temporary urgency ordinance.
Right. This temporary urgency ordinance, the one that contains this 100 collective lottery, it does some really terrible things to the rights of the people who are viewing this video right now. These are people whose collectives have been threatened with shutdown letters because either they didn't get notice or know about the lottery because of the short timing that the city used. These are people who also never got hearings under their hardship applications, even though the judge in the prior ruling said that one of the problems with the city's approach was it gave no due process and no hearings. These people have pre-existing non-conforming uses that existed back before the existence of any legitimate ordinance, and they should be treated like other non-conforming pre-existing uses. They should be allowed to stay open, to work through some time to pay back their amortization of their expenses, and it's just not fair to take someone's property without due process. And I think another thing that's upsetting about this ordinance is it continues to have the same old cutoff date, a very arbitrary cutoff date that for the most of the people viewing this is going to be the death knell of their collective. Why should collectives be ineligible if they opened up after September 2007? It's totally arbitrary. There are some other things that we've discussed that are objectionable.
It's absolutely arbitrary, it's irrational, and it's one of the reasons we find the temporary ordinance objectionable. Another is that each and every one of them should be entitled to be open. One of the arguments we are making in connection with the new ordinance is that there is partial federal preemption. As a result of partial federal preemption, the state can decriminalize the use of medical marijuana, but that's it. Local municipalities can license collectors, but they cannot do more.
Yeah, they can't over-regulate them because federal law specifically says
they cannot regulate at all under the partial federal preemption argument.
So that's a juicy argument.
The federal government occupies the field totally. All the state can do is decriminalize, and it has done that. Its statutes have been held to be constitutional. We're arguing that the local ordinance, which attempts to regulate, is unconstitutional. And as a result of that, each and every one of these collectives should be allowed to be open and operating.
That's right. And besides, one of the essences of our way of life is the freedom to choose those people with whom we wish to associate. If a particular group of people have joined together to associate to provide their medical marijuana in this state, I don't think it's fair for the cities to destroy those relationships and force other relationships on people. And what about the city forcing cultivation? How can the city force the collectives to commit 2 federal crimes instead of just 1? If they want to just sell, is it fair for the city to mandate that they also have to grow in the location? That's one of the requirements in the new ordinance, isn't it?
Yes, It's absolutely unfair, and we argue it's also unlawful. The city has not obtained a California environmental impact report. It has claimed that growing on site within the city of Los Angeles will not impact the environment. That's hogwash. There will be at least 100 collectives. There are at least 300,000 medical marijuana patients in the city of California. There are going to be at least 30 million plants being grown within the city of Los Angeles, all involving chemicals and other pollutants that will cause groundwater problems, other problems in Santa Monica Bay, to mention only a few.
So the bottom line is we have a lot of legal reasons why the ordinance can be challenged. We have already put together a 50 or 60 page complaint. I haven't seen the latest version up to 60 pages yet, but we have a lot of really juicy arguments, and I'm really excited about presenting them. Now, Graham, you've been a lawyer here in California for 25 years. I know you also had a legal career in New York and back in Great Britain. You have quite a long, although you're such a young and dashing-looking young man.
Well, I've been a lawyer for 38 years, and as you say, 25 of them have been here in Los Angeles doing high-profile litigation.
And you've also kicked some ass in this last litigation we had together in which we got this ordinance. You're totally familiar with Judge Moore. What's your take on Judge Moore, the judge that we will be likely in front of for our supplemental complaint?
I think he's an excellent judge. He's worked very hard on these issues during the course of 6 months of argument that we had before him in connection with the medical marijuana ordinance that's now on appeal.
Yeah, and I feel
he doesn't always rule our way. He's fair, balanced, down the middle of the road, and gives well-reasoned opinions. It so happens that his December 10 order issuing a preliminary injunction found largely in favor of most of our arguments. And as a result, the ordinance has to be substantially rewritten, hence the temporary urgency ordinance, which we now invite you to challenge.
That's right. So those of you that are viewing it, we've got a kick-ass legal team that wants to make this happen for you. We really have, can't guarantee in the legal profession, as you know, we can't guarantee an outcome, but we wouldn't waste your time and money and your rights if we didn't have a belief in our heart that we can do a great job for you guys again. And those of you that have held back in getting an attorney because it's extremely expensive, we really believe with the right number of collectives joining us, we can bring the price way down and make it reasonable for everyone to get kick-ass legal representation. Graham, you're a big part of that. Thank you so very much for all that you do, and congratulations on the prior ruling, and let's kick some ass together on this next one together.
You're welcome, and I look forward to doing so.
So there's the master plan. We are going to utilize the tried and true method of the checks and balances of our judicial system acting when the legislature and the executive get out of line. We're going to go to court and seek an order from the same wise judge who granted us an order last time against the city of Los Angeles, and we are going to explain all of the different aspects of this new ordinance that are unfair to you. So the idea is to get you represented, and if we are lucky enough and work hard enough and the judge goes our way, then we could have you named on the next order that we get from a judge, enjoining the city of Los Angeles from enforcing this new horrible ordinance against you. So that's the game plan. The more the merrier. The more people we can get hooked into this case, the cheaper we can make it for each one of you so that it's a reasonable expenditure for your collective. We know you're nonprofit. We know you're doing the best you can for your plaintiffs in these tough times, and the idea is for us to work together to help save safe access for the city of Los Angeles. So, you know my contact information. It's 888-420-LAW-1, 888-420-LAW-1, or the local number 323-540-4420. 323-540-4420. My office is ready to receive your call from 9:30 to 4:20 Monday through Friday.